Welcome to Pause for the Truth, where you can sit back, relax, and hear an honest dialogue about health, wealth, legal, and social issues. The hosts are Dr. Rogers Kane, family practice physician, and Jocelyn Turner, health education consultant, with co hosts from the Northeast Florida Medical Society and its foundation. Stay tuned for the truth about matters affecting you and your family. We're here to tell you what's really going on and why.
So that means I'll just
Good
drop it.
evening and welcome to Pause for the Truth. I am Jocelyn Turner, and that probably was a familiar voice in the background. Dr. Kane, my co host, is having some technical issues, and the behind the scenes guy is on camera this week as he works out the kinks with Dr. Kane getting on. Again, I am Jocelyn Turner. Thank you for joining us on Pause for the Truth. I don't know where you are, but it's going to be real cold here in Northeast Florida tonight. I didn't even realize it because it's like 50 something degrees now. And oh my goodness, it's going to get down to 27 degrees here in Northeast Florida. And I always have to say, please make sure that you check on your loved ones, particularly those senior adults who may live alone. Make sure that they are safe and prepared for the cold weather. Unfortunately, sometimes they don't adjust the thermostat in their homes and or they rely on space heating, which obviously can be a dangerous situation. So again, don't make an assumption that another relative is going to check on them. You check on them. It's better safe than sorry to get multiple calls and eventually they'll tell someone, why are all y'all calling me, right? But just remind them it's because you love them and you want to make sure that they are safe. And if you are using space heaters, make sure that you are using them properly so that you won't have a fire and cause harm to your family. And by the way, don't leave your pets out on chains. Please, please, please make sure you bring those pets in, put them in your garage, a shed, or something if they are outdoor pets, because tonight the temperatures are going to be too frigid. So that's my public health announcement. I am not a meteorologist. I am simply a concerned person and want to make sure everybody is safe. And of course, regarding your home, make sure that you cover those pipes if you have a home older than 25 years. I just heard that, by the way. I didn't know that it was a home over 25 years old. So tonight we have some. First of all, let me just go ahead and say, behind the scenes guy, how are you, Tyrone Jackson? You're muted.
I am doing awesome. Thank you for asking. This kind of weather is great for me. I love it. I'm from the Midwest. I feel beautiful and warm. I love it.
No, sir. I am a Floridian all the way, and I don't like it. I mean, okay, occasionally it's okay. It really makes you feel like you're in winter. Well, tonight we have an awesome discussion. I have the pleasure of meeting these two, and I'm going to go ahead and say it, even though I'm just meeting them. Brilliant attorneys here in the area. Never met them before, but looking forward to tonight's discussion as we talk about a subject that is near and dear to my heart, and that is estate planning and trust. Why do we need them? So we're going to learn about that tonight. Joining me tonight are Amber Donnelly, Esquire, and Latasha Green Cobb, Esquire. How are you both doing this evening?
I am well. Thank you so much for the opportunity to join you this evening. And I'm looking forward to the sexy topic of estate planning and trust.
All right, now the sexy topic. I love it. I'm excited. And thank you and welcome. Thank you for taking your time to be with us this evening. And again, welcome, Miss Green Cobb. How are you doing this evening?
Doing well. Thank you again for having me. And I am excited about sharing more information to our vulnerable communities as well.
Yes, indeed. And make sure, ladies, that Tyrone is going to give you the opportunity, and he's probably going to tell you. So I'm going to go ahead and give you the heads up. At 7 o'clock, we are going to pause for a moment and have our history maker moment. And at that time, if you could just drop your contact information in the chat box so that our audience will know how to reach out to you, as I know they're going to want to do it after we engage in our discussion tonight. So let me just go ahead and tell you all that, and I'll start the conversation, that a few years ago, and we typically don't think about estate planning and doing a trust until a loved one passed. And for me, it was when my father passed almost 14 years ago. And it was at that point, but I was a little smart. And I say a little smart because we knew that he had a terminal illness. So I had the opportunity to have a conversation with him about his business. And I had been helping him to manage his affairs a few years before that. So we were semi-prepared. And so I'd just like to ask you all and I don't know if I should start out with a negative, but I'll start off with a positive. I won't go there. I was going to say, why do you think people don't want to? But I'm going to start with, why should we have an estate plan and or a trust? And is it just for people who have assets to protect? Who'd like to take that question first?
I don't mind taking that. So I know that trusts have become very popular in our community. I personally do recommend that you touch base with an attorney in order to know whether or not you should have a trust. Trusts can be a bit expensive, but they're about, sometimes run about neck and neck in terms of just getting a will. A will is a little less expensive, but obviously, as I often share with people, if you do not take the will to the court in order to enforce it, it's just a piece of paper. So that's where, the misgivings come, where people feel like, well, will isn't effective enough because I have to take it to the court. But on the other hand, with the trust, you can do that, most of it outside of court. However, I am one of those that, I look at our clients' assets to determine whether or not a trust is absolutely necessary. Ms. Donnelly, Attorney Donnelly may have a different perspective with that, but I know that oftentimes I'm dealing with vulnerable communities that have fewer, resources in order to get these documents. So I'm looking for ways to make sure that they can have an established plan as to how they want things done in their untimely demise, or in the case of a natural transition because they're older. But that's just my perspective on it.
Thank you. I appreciate that.
And I'll jump in here and start with your positive. Why should people take the time to get an estate plan in place? And the reality is, we all have people that we love and care for. And
Hopefully.
if you're even if they're not family, they're distant friends, right? You have people that you love and care for. And for my perspective, it's really about loving your family enough to have a plan in place should something happen. For me, it's about being responsible and a good steward over whatever you've acquired during your lifetime. And that's different for everybody. But are you going to be responsible and plan in advance and not be in crisis mode when something happens? Are you going to be responsible enough to have some of these tough conversations to make sure your family and loved ones are good? So just being responsible and loving your family enough, from my perspective, is a reason to take the time to get an estate plan, whether it's a trust or a will or the other estate planning documents that are necessary to complete the plan.
Can you, for those persons who may not know, can you tell us the difference, one of you or both of you, tell us the difference between a trust and a will? Because I don't like making the assumption that people know the difference. So can either of you do that, explain that, please?
So I'll tackle the will if you want to tackle the trust, Ms. Green Cobb.
No problem.
So the will is basically a document that identifies who you want your property to go to. Who gets the house? Who gets the car? Who gets the job of serving as the personal representative and managing your final affairs and hiring the attorney if probate is needed? So it doesn't legally transfer the title of any of your assets, whether it's a house, a car, or a personal items, but it identifies your wishes in terms of who you want to get these items to.
Okay, thank you.
You're welcome.
And so a trust does something very similar, except the trust actually has those titles done while you're alive most times. Now, a trust can be done, after your death as well, but typically that's noted in your will that you want to have a trust, but otherwise the trust, in order to what we call fund the trust. So you determine that you want to create a trust document. And many times that's because you have an excessive amount of assets that would put you in a place where you will most likely have what people like to term the death tax. So you put those items into the title of the trust. And so that's a very, not overly difficult process. It depends on the amount of assets you have, but that can be your home, that can be your cars, that can be jewelry. It can be any number of things. The only difference with the trust is that you don't typically have to go to court in order to enforce it. Where in the will, you will have to go to court for that document to become enforceable.
I
And
tell
if I
you
may
what,
add something to that,
sure.
a big difference between the two as well. So the will says, this is who I want my property to go to. The trust not only transfers the title during your lifetime, but it also allows you to leave instructions for the trustee on how you want that property managed, how you want that property distributed. Sometimes I have clients and I call it a side deal. Well, this is what I really want you to do, having a conversation with a loved one, but it's not in writing. I'm putting your name on the bank account, but I really want you to give it to Junior. Those side deals, I call them. But in your trust, the proper way to do it, you can leave those instructions for the person who's managing the property and tell them how you want those items distributed and at what time periods you want them distributed.
I tell you what, one of the biggest challenges for me, my family members are hearing, hopefully they won't knock me off, but was determining who to entrust your business to in your, if you have an untimely death, or even if, at whatever, who do you trust with the medical surrogate was the toughest for me, in terms of determining who would make those decisions. And you have to make sure that you are in alignment with the other person of how you feel, for example, about putting yourself on life support. These are conversations that we need to have with our loved ones. And for whatever reason, it seems to make people uncomfortable to have those conversations. It's as though people think, well, I'm not going to let them know I'm leaving the money because they might bump me off, right? Like, I don't have that much money. Wait a minute now, right? But the most important part for me is to make sure, because, I've gone to nursing homes, for example, and I see those people, the older people who are there crying out for people. No, and I've been told by some of the staff, no one comes to visit them. And so it just makes you wonder. Those are the things that you think about. We have a question. Do you have to designate a trustee?
Actually, you typically will designate a trustee. Otherwise, the court may designate that for you. But generally, you want to identify who your trustee is and who's going to be the successor trustee.
Yeah, and I always say that when I do it, to do it now, they won't know who it is until you're gone, and they can't get mad at you at that point anyway. It don't really matter, right? So you designate whoever you want. And I don't know why people feel uncomfortable about that. Obviously, because unfortunately, when it comes to money and assets, people they change. Their whole different personality comes up. Dr. Kane, did you have a question?
Yeah, good evening, ladies. I didn't get a
Good
chance.
evening.
Sorry, I was having some technical difficulties that I couldn't straighten out before the podcast. What are the advantages of even having a trust versus a will?
You avoid going to the court.
And
Is oftentimes what happened. That's one of the things that most people prefer. A will is often published, so it kind of puts people into your business in terms of what is being conveyed. And on the other hand, with the trust, most of that is hardly ever publicized.
are there any tax advantages or
Definitely.
yeah,
Definitely.
that's kind of something I guess I was kind of inquiring about, particularly when you leave something to your kids. If you put it in a will, and I'm just asking because I don't know, if you put it in a will, are there estate taxes depending on that can be assigned to the recipients of that trust money or those monies is, versus when it's in a will. Okay, so the financial advantages of a trust versus a will, and is there such an animal? If I'm asking the question correctly, other than just not having to deal with the courts.
Yes, there can be financial advantages.
Okay, and things like Medicaid planning. Sometimes those individuals, there's an advantage with Medicaid planning with a trust versus a will, and or because there's a couple of different types of trust. And as I was saying to Ms. Donnelly before we actually got on air, I'm not an attorney and I can't play one on television, but I would kind of want to try to figure out with my patients and myself, trying to figure out what is the best position or best way to ensure my family members receive the legacy and monies or whatever it is that you want to leave them without them being taxed to kazoo and transfer those monies without them being eaten up by court costs and or other obligatory other obligatory taxes or whatever that may occur after I die, if that makes sense.
So I will start with, a lot of people think of the federal estate tax and the family being taxed for estates. So me saying this is going to knock out probably half of the audience. You're taxed at 13.61 million. And so if you're not there yet, federal estate taxes don't apply. My approach when meeting with clients is, one, I want to find out what your assets are, who your beneficiaries are, do they have any special needs, who are the people that you're going to give a job to? And to Ms. Turner's point, you want to identify people who are responsible, people who can make the tough decisions. And I'll add this, you do want to let them know in advance that they have a role, because what if they don't want it? When you're planning is the time to know that, so you can identify alternate folks. But I think what some people don't understand is sometimes estate planning isn't one size fits all. And that's why it's important to talk to a professional who can get to know you and your wishes, your assets, your beneficiaries, any special needs or concerns that you have, so you can properly plan and create a plan that will work smoothly for you and your family, or as smoothly as possible. Some people, I meet with them and I'm like, you don't need a trust, depending on what their assets are and who their beneficiaries are. I will say with a will, there's more things we can do in terms of planning. If your house is paid off, maybe we want to put it in an enhanced life estate deed. Some people call it a ladybird deed. If you have bank accounts, those can avoid probate. Put your beneficiaries and an alternate beneficiaries on your bank accounts, retirement plans, investment accounts, life insurance policies, and those monies avoid probate. If you have cars that are paid off, you can take a death certificate and say you're the next of kin and complete the affidavit. They'll transfer the title. So it just depends on what you have in terms of assets, who your beneficiaries are, if there's any special needs, and we can create and craft a plan that'll work for you. But for those who are concerned about federal estate taxes, we're looking at 13.61 million plus to really have that conversation.
So what, before someone decides to come to you, when you talk about those assets that you have, what can they do in advance? Should they write down all the things they own, the things that are in their, property or assets that are in their name? Because for me, when I went, for example, I also have a small business. So then it came to doing the business trust as in addition to my personal trust. So can you talk about that? Can they do their homework or have some things in, or should they just come to you and you'll counsel them accordingly?
So I would definitely recommend that they have a list of their assets and even, some idea as to other things that need to be paid out in the midst of their property, whether that's real property, which is, actual land, or personal property, which pretty much encompasses everything else, such as jewelry, china. Those are the type of things that we often see being conveyed in a will or a trust. So if they have those items written out, even the things that Attorney Donnelly mentioned in terms of the bank accounts, we often talk about those things can be handled when they operate outside of probate because they are actually based on contractual law. So if you have that information already designated to those financial institutions, they don't need to have probate dictate that. So definitely would recommend that they have some ideas, some listing. That's one of the big things about wills or trusts. You need to have some idea of your bounty in terms of your relatives, in terms of what you own. To answer some of the questions that have been popping up throughout the podcast, the computer programs. Now, Attorney Donnelly and I probably can agree on this one point. I don't recommend computer programs for wills or trusts. They actually create more problems than they resolve. I know that they're, oftentimes more affordable, and so that's why people engage with them. But sometimes they create more issues, especially when you're dealing with documents that still have to be probated in the court. I feel I spent a lot of time trying to figure out what was actually what the decedent wanted and how to fix some of those issues. As to the average cost of a trust, again, that's going to be dependent upon the professional that you're working with. But I would say I'm personally licensed in Georgia and Tennessee. However, I do have attorneys on staff that are licensed in Florida and New Jersey. But I will say you're probably starting at about $2,000 for your average single individual. If you're dealing with a couple, that may go anywhere from $2,500 and up. Attorney Donnelly, I don't know if your numbers are a little different.
So I'll start with I'm cringing on the inside about the thought of somebody using a computer program, especially if you don't have the knowledge to back it up. You don't know what the law says. You don't know what the nuances are regarding estate planning. It's like me going into Dr. Kane's office and trying to prescribe people medication and figure out what the issues are. I don't know. I can make something up. And in some cases, people don't truly understand what they're preparing. They can fill in the blanks, but don't understand the information behind the blanks, don't understand the law. And so my recommendation would be, even though it may be more cost effective, at least have a consultation with a professional so that you know what you're doing, that you have a sense of direction if you decide to go it along. And something Ms. Turner mentioned earlier about kind of what do they need to start doing in advance. When people meet with me, they get a comprehensive intake form where they have to list out their beneficiaries, their assets, their debts, their alternate beneficiaries, their financial assets, their tangible property. And so that process gives them an opportunity to assess and do an inventory of where they are. In terms of cost, my lawyerly answer is it depends. And it really does. Going into 24, I'm limiting the amount of trusts that I'm preparing, but I'm starting at $5,000 for a trust. Individual, couple, whomever, at a minimum $5,000.
You know what? I'm glad you all mentioned the cost or someone mentioned cost, because Dr. Kane and I have this conversation often. And no, I'm not throwing shade on anybody. But when it comes to things that really matter, like this and our healthcare and education, we'll question. But when we walk into the beauty supply store and get some hair or whatever, I mean, I just have to go there. I mean, you know what I mean? And so I think the value that we place on stuff really needs to be evaluated. And because I've never been there, I've heard that probate court is quite entertaining and sad, that the drama that families go through and put their business out in the court and let the court decide, that people cannot have mutually respectful conversations to help determine the assets of their loved ones, grandma, whatever. And then I look at numerous properties here in Jacksonville. I've had a conversation with Dr. Irvin Cohen about heirs property, right? People have received property from their heirs, and I always think that they're, older people worked hard to get those properties, and for their heirs to not take it as serious is so sad, because they don't know what people went through and sacrificed in order to get that property. So that's my throwing shade moment for the evening. There's a question: are there payment plans for your services, wills, or trust?
I can't speak for anyone else, but our office, and the reality is, once we create that document, you have it in your possession. So we don't have a payment plan.
You can't take it back.
They don't have a payment plan at the hair and nail salon. I'm just saying, Attorney Cobb. What about you, Attorney Donnelly?
So for estate planning cases, I do not have a payment plan in place. I typically just charge a flat fee so people know what to expect. I'm not billing hourly and then you have a surprise bill at the end. But at the consultation, they'll know what the price is. It'll be a flat fee from start to finish, whatever it takes. I will say there have been instances where I've bended my rule regarding estate plans because maybe the person really can't afford it, and I go over their estate plan with their what they need based on the consultation. And sometimes I've done it pro bono. Don't come to me making 6-7 figures wanting pro bono, but there have been people who don't have much and I'll do it pro bono, or people who share with me that they need some assistance, and I can be flexible, but my baseline rule is to take the full payment up front and from start to finish.
I just want to remind people what pro bono is, and that means free. So don't be
yeah, pro bono is free. And so in our office, in order to get pro bono, at least on the Georgia side, we go through Georgia Legal Services Program. And so they do their vetting, and I trust their vetting. So that's the only way that you typically get pro bono from us.
So now we're going to pause for a moment. Don't you all go anywhere. Get your water, take a little breather. We're going to come back and engage in more discussion. But it's at this time of the show that we pause for our History Maker moment. Take it away, Tyrone.
Hello and welcome to Pause for the Truth's History Makers Minute, January 16th, 2024. As we reflect on the past and present, it is important to recognize the people who have made significant contributions to America and the rest of the world. Today we present Dr. Martin Luther King Jr., born January 15th, 1929. Dr. Martin Luther King Jr. is indeed one of the most recognized names in history. However, as time passes, it is easy to forget his contributions to the civil rights movement. The movement, led by Dr. King, fought for desegregation in public accommodations and facilities, aimed to dismantle Jim Crow laws and end racial discrimination in access to public spaces like restaurants, hotels, and transportation. Dr. King's leadership and activism were instrumental in achieving several milestones in the civil rights movement. Here are some of his most prominent accomplishments, too. Led the Montgomery bus boycott in 1955, which ended with the U.S. Supreme Court ruling that segregation on public buses was unconstitutional. Founded the Southern Christian Leadership Conference, SCLC, in 1957 to coordinate civil rights efforts. King was the president of SCLC until his assassination in 1968. Led the Birmingham Campaign in 1963, which ended with the municipal government changing the city's discriminatory laws. organized the March on Washington for Jobs and Freedom in 1963, which was attended by over 250,000 people and laid the stepping stone to the passage of the Civil Rights Act, 1964. Dr. King's legacy continues to inspire people around the world to fight for equality and justice. His contributions to the civil rights movement have made a significant impact on society and continue to shape our world today. Dr. King did not do it alone. There were many dedicated soldiers fighting alongside him and even more behind the scenes. Here are a few names to remember. Ralph Abernathy, a close friend of Dr. King and co-founder of the Southern Christian Leadership Conference, SCLC. Bayard Rustin, a civil rights activist and organizer who helped plan the March on Washington in 1963. Dorothy Height, a civil rights and women's rights activist who served as the president of the National Council of Negro Women. Ella Baker, a civil rights activist who worked with the SCLC and helped organize the Student Nonviolent Coordinating Committee, SNCC. Andrew Young, a civil rights activist who worked with Dr. King and later served as the mayor of Atlanta and as a U.S. ambassador to the United Nations. Fannie Lou Hamer, a civil rights activist who helped organize the Mississippi Freedom Democratic Party and challenged the all-white Mississippi delegation at the 1964 Democratic National Convention. Septima Clark, a civil rights activist and educator who helped organize citizenship schools to teach African Americans how to read and write so they could pass voter registration tests.
Wow, I've never heard of Septima Clark. So every time we do this, Tyrone will add someone that's new to me. But as I was listening, every time I see Martin Luther King Jr.'s, Dr. Martin Luther King Jr.'s birth date and death date, he was only 39 years old. And you think about the things that you accomplished in your 30s, and OMG, did he leave a mark and accomplish so many things in such a short lifespan. Thank you, Tyrone, as always, for your doing your homework and putting those history maker moments out there with us. One thing I would like to ask, if someone could explain real quick, what does it mean what is probate court, or what does it mean for things to go into probate?
So probate court is a legal process to transfer ownership of assets from the person who has passed away to their family members. In that process, in the state of Florida, and I'm licensed in the state of Florida, my office, Donnelly Law Firm, is located in Orange Park. So in the state of Florida, if you have to go through probate, you're required to hire an attorney to assist you with the process of identifying the assets, identifying any creditors, and also transferring the property to the proper beneficiaries. So it's the legal process to transfer ownership, but then also in that process, you have to deal with creditors.
So it sounds like you pay me now, pay me later approach. You know, you can pay it while you're alive, or your family can pay it once upon your demise. And so the money is still going to have to be, and probably more money is what it sounds like. That's the reason I brought it up earlier. Probably more money, a lot more money is going to be paid if you have to go through probate court. Because like you say, you got to pay that attorney to help sort all that out. And that will, they bill by the hours. So if you call them and say, hey, how you doing? You know, and they're going to discuss everything they can with you before they get to your case. Not everybody, obviously not right. You ladies, but they may discuss everything they can before they actually get to your case. And so, particularly if you get the wrong one, as I was saying, that's a lot of money to pay. So why not just do it up front? You know what the cost is. You know what the outcome will be. And it's just a lot simpler to do that up front. I found one other thing that, and you guys can correct me if I'm mistaken, there's not some people in the King family, because that was the probate take a place in terms of Dr. King when he passed, and there was nothing outlining exactly what went to certain members of the King family, whatever that might be. I can't remember the exact things that were at discussion. that were taken to court, but there was an issue in terms of his family, if I'm not mistaken, that had to go through the court system, and that caused a whole lot of stress upon the family system at that time.
I will say it can be stressful, but sometimes probate cannot be avoided depending on if you had a plan and the type of plan that you have. I will say any items that have to go through probate, it is helpful if there's a written plan in place that's properly signed and executed and prepared, because at least we have a roadmap. I will also say that even having a plan doesn't mean that people won't fuss and fight. You know your folks, you know your family members, you know who's going to act up. I come from a big family. There's 9 of us. There's a lot of personalities having 8 siblings. And so you can't always predict how people may behave in the process, but having a plan in place and a roadmap to follow that's properly executed can definitely help. And to your point, excuse me, doctor, there have been a lot of celebrities in the news who are generating all this money and don't have a plan in place. And what happens when someone passes away, no matter the value of their assets, the state will step in and determine who that property goes to. And it just gets more complicated if you have a blended family, or now you're on your second or third spouse. Things can definitely get challenging. And so at the end of the day, you can't predict everything that's wrong. You can at least take the time to plan so there's a roadmap for your loved ones to follow.
And the big thing that determines what the rules are is the jurisdiction in which that individual is in. And the reason why I use the word jurisdiction instead of just state is we have DC, which has its own rules, and it is not an actual state. We have other territories which have their rules, but are not actually states. So the law tells you how property is to be dispersed if you don't have anything in writing. So that's one of the reasons why you want to have a will, because then everything just kind of gets dispersed based on the law. The will actually gives you an opportunity to override what the law sometimes says. Now, there are other exceptions to that in terms of you can't omit, a minor child or certain things like that. They're going to, make sure that those individuals are protected. But for the most part, your will is giving direction as to how things are done. The trust is giving direction to how things are done. But yes, there are plenty of celebrities who have transitioned and for whatever reason did not have anything in place. So I think it's wonderful to have this conversation to discuss how to get your things in order. Because, nowadays people are passing out of order all the time. That's what my little joke is. It used to be back in the day, you only had the older individuals passing away, but now people are dying young. So, we have to have these conversations and get things in order. I would definitely echo Attorney Donnelly. As wonderful as family members might be, when you get money involved or assets involved for that matter, it gets really, really contentious. And sometimes it's difficult to have the conversation, but it's a necessary conversation.
I can't get past how many, I have a lot of patients, a lot of my patients are geriatric, and and as you said, you don't have to wait till you get a certain age to try to come up with a will or whatever. But I have, I can describe a number of times where I've had this daughter or this son be the ones who always bringing in their mom, bringing in to see me, as bringing them every office visit, taking them to all the appointments and yada, 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 yada. And then turn around, and when that person passed or they're near passing, all of a sudden we have these family members that want to know from me exactly what took place with their illness. And, and the first thing I go, well, who are you? and they say, well, I'm the daughter. And I'm going, I didn't know she had a daughter, because you never came with your mother's appointments and stuff of that nature. Or that they also sit back and people coming out of the woodwork where the sister or cousin, whomever, because they had this farm property somewhere, and all of a sudden they show up after the demise of that patient, and then try to get me cornered, into put me in a position of where I need to come to court and testify on their behalf and in their favor of what the intent of my patient, what my patient's intent were in terms of passing on their assets. And it's just so ridiculous that that person who's been taking care of that mother or father or whomever it was, aunt, uncle, taking care of them for 10 years, and I've seen them, only them for 10 years, and then all of a sudden, these other people coming along and making things so complicated that it's just ridiculous. And so that's one of the reasons I wanted to make sure that you ladies or someone came, that we have this discussion on estate planning, because I just got too many cases where there is no estate planning done, and we need to, especially, I hate to racialize it, but especially as Black folks, we do not go out and try to plan our demise in the sense of what happens once we're gone. Not the way you want to get rid of me because you want my money, but or what money you think I got. But we just need to do better planning.
Well, and I would think, Dr. Kane, you would come in on whether or not the decedent had capacity. That's one of the big things that gets called in question when, individuals have transitioned and they have that will or trust in place. Now they're questioning whether that individual actually had the ability to make those decisions.
Exactly.
Or they're questioning whether or not these other individuals that were coming into the doctor appointments with them, if there was any undue influence.
Right.
So, all of those things get called into question. And, that's why we as legal professionals have to be careful about, if we have any question as to whether or not a person can make decisions for themselves.
And we have a lot of, we're seeing such a increase. I don't know if that's because of better techniques and discovering, better testing and discovering, I don't even want to say mental illness, but dementia or whatever stage of dementia it may be, or is it that we're just actually seeing a lot more in the general population? I'm saying I just see a lot more in the general population, and we need to really start trying to address this within not only the medical community, but the legal community, and then within our families.
What about people who have children or minor children when it comes to their trust or their will? What type of planning or guidance do you typically give them to have? Should they have someone who's designated? And so say, for example, if it's a single mom or even a husband, wife, and they both go at the same time, right? And then what happens with the children and whatever assets are already designated for their offspring?
So this is actually something I can address as well. As Attorney Donnelly, we actually had a personal situation wherein a nephew got killed in a motorcycle accident. And so, his wife is left with two small children under the age of 10. And so immediately, even though I'm not licensed here in Florida, I'm immediately saying to her, hey, you need to get your documents in order, because God forbid, if something happens to you, now we don't know who you want to have the children, who you feel is prepared to take care of these children in your absence. So that is definitely something we recommend, even with people having children now later in life, because, there's still some people having children, at 50, 55. And that's another thing I say, even though you should still do it. Me personally, I had my first will at 23. And that is primarily because my mother passed away. And so it became very important for me to get those things in order. But I do recommend it for our seasoned parents, that start a little later in life to go ahead and designate who they want to care for their children in their absence.
And I think it's twofold. Identifying the pre-need guardian, the person who would take care of your child, but also the person who can manage the finances. And sometimes that's not the same person. And being able to identify in advance who those people are or who that person may be. And I typically recommend a trust for people who have minor children, depending on what their assets are. You don't want to leave a $1 million policy to little Ray Ray. You want to make sure that there's a trustee, that you leave those instructions so that the money can be managed for little Ray Ray. I will give you, something to consider as well when you're talking about minor children. Again, just the paperwork, identifying the pre-need guardian is not sufficient. That person who's going to be caring for the minor child is going to have to hire an attorney to become their legal guardian, and that's through the court process. And then if those assets are $15,000 or more in the state of Florida, you're going to have a guardian appointed to be able to manage those funds. So the paperwork itself is not sufficient. You can't just go pick up little Ray Ray and say, oh, this paper says I'm in charge. No, you need to hire an attorney, go to court to become their legal guardian. And that comes with its own set of rules and requirements. And it's a process as well. But it's twofold. Who's going to take care of these babies and who's also responsible for managing the assets?
You mentioned about hiring an attorney. I just want to make sure. So should I, if I'm no longer a young person like that, so I don't have to worry about it from that standpoint, but I did take care of it when I was younger. Should I try and designate who I want the attorney to be, within the will of trust in itself?
If you have a preference, you can definitely designate who you want to serve as your attorney for probate, or to identify somebody your family can reach out to in case something happens. They're not obligated to use that attorney. But I typically, as a part of my process, when I'm done with an estate plan, everybody that has a role in that estate plan, not a beneficiary, but if you have a job to do, I'm sending you a letter, because if you have questions about that role, I want them addressed now. And so that you know what's expected of you. I don't talk about the details of my clients' plans, but I talk about what the role of a personal representative is, what's the role of an agent in a durable power of attorney, what's the role of a healthcare surrogate, so that people who are part of the plan are aware that they're in the plan, but also understand what the responsibility is.
What's a durable power of attorney?
So a durable power of attorney is another estate planning document. So we've been focused really on the trust and the will, and those typically come into play for a lot of folks after they've passed on. But there are documents that you can get during your lifetime so that people can step in and assist you with financial affairs or medical affairs or end of life decisions. And so typically the durable power of attorney, it's durable because even if somebody becomes incapacitated, it's still a valid document. Someone develops dementia, has a stroke, is in a vegetative state, that durable power of attorney is still effective. And you're giving someone authority to manage your financial affairs or your medical affairs. And as soon as it's signed in the state of Florida, it's valid. And so that's important for people to know.
If it's a family member, that's an attorney, would you suggest them having the durable power over the durable power of an attorney? Let's say your daughter, one of your daughters is an attorney, okay, and you put them as durable power of attorney. There's some disadvantage to that, I know. Or maybe they can potentially disengage some of the other family members. If there's other ones that's also mentioned, other siblings or something along that line. It look kind of a pitfall in there. Is that a pitfall?
So your power of attorney should only operate to your benefit. So the power of attorney isn't, let me do whatever I want to do, no matter what this person wants. The power of attorney acts as your agent. So they are actually executing what is in your best interest. And so unless something was in your best interest to disengage someone else, then that shouldn't be occurring. The other thing I would state is that I wouldn't have a daughter or a son who is an attorney execute your power of attorney.
That's my question.
Mm-mm.
Okay.
No,
And
get someone
those
else
who-
to draft that, to draft it and have it properly executed so it protects the undue influence we talked about earlier.
there you go. I just wanted to raise that because I know of a situation like that.
So as a durable power of attorney, does it include the medical surrogate piece, or could that be a separate person?
They're two different forms for
Okay.
most offices. Yeah. So for us, your advanced care directive, it'll cover things like how you feel about autopsy, how you feel about if you're in a state of, an incurable disease, if you want to, be on a ventilator, if you want to have a feeding tube, if you want to have pain medication. It's going to cover all of that. It will even cover whether or not you want to be buried or cremated. If you want to leave that completely up to your healthcare surrogate, then you can, but typically it gives you the opportunity to state what you prefer. And that healthcare surrogate, again, very similar to the power of attorney agent, is supposed to carry out your wishes. Unless it's just, completely, outside of their control, because maybe the funds aren't there for them to carry out your exact wishes.
And what is that document called again, Attorney Green-Cobb?
In Georgia, we call it Advanced Healthcare Directive. I think
Okay.
it's something similar here in Florida.
It is. I have all my patients.
Yeah.
All
And
my
then
patients-
more specifically, a healthcare surrogate, where you're identifying who makes your healthcare decisions if you become unable to, which is a separate document, but under the umbrella of advanced directives, and the living will, which identifies whether or not you have a will to live if doctors are saying there's no medical probability of improvement.
And they, some people may list one of, let's just say, as y'all mentioned earlier, they may list the other spouse in terms of health care surrogate, but should there be dual demise, meaning the husband and the wife both die for whatever reason, automobile accident, whatever it may be, then you need to name a second possibility and maybe a third possibility in case the family is out, except for one member, whomever it may be, that the death occurs among all of those individuals named as far as your healthcare surrogate.
I'm about a plan A, a plan B, and a plan C if we
That's
need that
exactly
too.
what
So
I-
definitely having alternates is important.
So we're at the end of the show, and this has been very educational. I learned a lot, and we definitely are probably going to want both of you to come back. Thank you so much for taking your time to join us tonight, as I know our audience has learned from you. At the end of every show, we like to give our guests an opportunity to share your final thoughts regarding tonight's topic. I will start with Attorney Donnelly. Oh, Attorney Green. Wait a minute, Tyrone. Stop switching the camera on me. On me. We'll
You're on
start
your
with,
toes, Miss Turner.
exactly. We'll start with Attorney Donnelly, since he has you in the big blocks. Attorney, what are your final thoughts regarding tonight's topic?
Well, first and foremost, thank you for this opportunity to share about this very important conversation. I would like to say avoiding the conversation doesn't prevent things from coming up in the family that need to be addressed. So be mature enough, be responsible enough, and love your family enough to start having these conversations and putting a plan in writing and using resources like an attorney to make sure that everything is done properly. Estate planning, it's a sexy topic, being responsible and leaving a legacy. And so take the time to do those things.
Thank you, Attorney Donnelly. I appreciate that advice. And we are also putting your information on our website for folks who would like to get in touch with you afterwards. Attorney Green-Cobb, what are your final thoughts?
I would like to also thank you guys for having me. It's been a wonderful opportunity to share about something that is so near and dear to me. My final thoughts as to wills and trust is definitely seek professional advice. Make sure that you are putting things in place. Make sure that you have the opportunity to speak in a final way to your family members as to how you want things handled, and just do what we call the possible. God handles the impossible, but this is something that you can do in order to make things a little more seamless for your family and friends.
Wow, thank you. That's pretty powerful right there. I mean, God does the impossible, and all we have to do is our part, right? And stop putting all the blame. And then, the whole fussing and fighting. But I'll save my 2 cents for my 2 cents. Dr. Kane, what are your final thoughts regarding tonight's topic?
Well, I'd like to thank both ladies for coming on and helping explaining the need for people to at least plan, and don't take it the wrong way, plan for their death.
Mhm.
Okay, plan for their demise, and how you should best help your family, how you could best help your family upon your demise and handling situations like this. I just want to make sure that both attorneys, as we say, be available for another show, because as much clarity as they tried to provide to to all of us about the subject matter, it's still going to be confusing to some, and they're going to need to have a more one-on-one conversation to get a better understanding. We just gave you guys, gave our listeners a quick opportunity to hear a 50,000-foot overview of what it's all about. But to each, for lack of a better description, to each his own. Your circumstances and your situations are unique, because you are unique. And so at least go and talk to someone. Hopefully these young ladies that we put on our podcast, or that have came on our podcast and volunteered to do so, hopefully you utilize one of their services. As much as I hate to say it, they are of your community, so they do. I don't hate to say it. I'm proud to say it. They are of your community, and when people come to see me, they identify with me because I look like them. So, and I have an understanding of some of the things that they may be going through, at least attempt to do it anyway. And so usually that's what happens. So utilize these ladies to whatever degree you can by checking out our podcast, listening of where you can, their location and how you can reach them. And we much appreciate them coming on our show this evening.
Thank you, Dr. Kane. And to our viewers, thank you so much for tuning in. Again, talking about your next phase of life, and that is your death. We don't know when that's going to happen, so why not plan for it? We plan for vacations, we plan for our weddings, our family reunions. When you have your family reunion, have that conversation with your family, because one thing that you want to do is maintain a happy family. And unfortunately, in many families, when their loved one passes on, particularly in many cases, it's an older loved one, and then they start bickering over assets. You don't want to do that. Your loved one would not want it to be done that way. As both attorneys said, if you cannot afford it, they may be able to help you. But again, I also say we spend money on stuff. Sometimes you have to put some money aside and save for and plan for. I think the main word I heard tonight is planning. Planning. One thing that we know for certain, when we're born, we're gonna die one day, right? That's for certain. So why not put a little money aside? You may not make a lot of money, but there's an attorney out there who might work with you based on your income. Thank you all for listening to us. In order to stay on the air, we do need your help. Please subscribe to our YouTube channel, Pause for the Truth. Now, as Tyrone says, hungry for the truth. He is so creative in his words. And, help keep us on the air. We'd like to make sure that the podcast is widely known, because we have great guests, such as our guest tonight. Tune in next week for Pause for the Truth. And thank you as always for joining us.
Good night.
Oh, and I forgot to mention we start featuring a Black business, a minority business, I should say, and it's McCoy Waterways for private boat charters.
Welcome to Pause for the Truth. We are grateful that you joined us today and hope you've gained valuable insights on our current topic. We look forward to having you with us next time as we explore trending issues in our community and discover ways to simplify life for you and your loved ones. Our dedicated panelists and staff are committed to sharing knowledge and serving our community. But now, we need your support. Please subscribe to our YouTube channel and spread this valuable knowledge to others. Don't forget to invite your family and friends to tune in to our podcast every Tuesday at 6:30 p.m. EST. Visit our website at www.pauseforthetruth.com and show your support by liking us on Facebook, following us on Twitter, and linking with us on LinkedIn. Feel free to email us with any questions, or concerns, or show topic recommendations at info@pauseforthetruth.com. I would also like to give thanks to our behind-the-scenes technology engineer, Tyrone Jackson, owner and operator of Call Tyrone. Go to www.calltyrone.net for a complete list of services. Thank you.